Mediation versus arbitration. What are they and which option is right for you? Hi, I'm Daniel Hunt, a certified specialist in estate planning, trust, and probate law. When conflict arises in a trust administration, some trustees and beneficiaries opt to try mediation or arbitration first, or instead of filing a formal lawsuit. Mediation and arbitration are two forms of alternative dispute resolution, ADR for short. Both provide a way to privately resolve the conflict outside of a public court proceeding. ADRs can be quicker and less expensive alternatives to an expensive formal lawsuit. What's the difference? Let's take a look at mediation first. Mediation is an informal arrangement in which a neutral third party acts as a mediator between the two or more conflicting parties. Each party attends a scheduled mediation with their attorney, if they've retained one, and presents their side. The mediator offers suggestions to help resolve the dispute. While most mediators are attorneys or retired judges, they're not supposed to give legal advice. Mediators do not issue orders, find fault, or make determinations. They do not have the authority to make legally binding decisions for the parties, but rather serve as a guide for the negotiations. What are common steps of mediation? Mediation doesn't follow a formal process like arbitration or a court proceeding. First, the mediator introduces themselves and explains the rules and goals of mediation. Second, each party gets the chance to explain the conflict as they see it without interruption from the other party. Third, the mediator often meets individually with each party, going back and forth to work out the issues. Fourth, if an agreement is reached, the mediator writes it down and all the parties sign the agreement, including attorneys if they've retained legal counsel. Fifth, if an agreement is not reached, the mediator may conclude by summarizing the points on which the parties did agree and advise them of their next steps. Now let's talk about some pros and cons of mediation. Mediation is usually the most cost-effective approach to dispute resolution. Mediation costs around $3,000 to $5,000 in California for a full day, while trust litigation in the form of a trial can cost many times more than that amount. Mediation is relatively quick, often lasting only a day or two. And mediation invites both parties to actively participate in finding a solution they find acceptable. This offers the parties more control over the outcome than arbitration or a court proceeding, where an arbitrator or judge makes the final decision. The downside to mediation is that it doesn't always yield a resolution to the conflict. Typically in mediation, there is no winner or loser. If the parties fail to reach a mutually agreed upon solution, then the matter may proceed to litigation. Next, let's take a look at arbitration. Compared with the informality of mediation, arbitration follows more formal rules of procedure. The arbitrator should be agreed upon by both parties and should have some degree of experience with trust and estate law. Like a mediator, an arbitrator is a neutral third party who listens to both parties present their side. Unlike a mediator, an arbitrator makes a decision that is typically legally binding to both parties. The arbitration process generally follows the following steps. First, one party sends a document called a request for arbitration or notice to arbitrate to the other party, and the document sets forth the nature of the conflict in that writing. Second, the other party has a period of time to respond in writing and indicate if they agree to resolve the dispute via arbitration. If so, the arbitration process begins. An arbitrator should be selected by both parties. The arbitration will involve one or more hearings before an arbitrator. Both parties' lawyers may present their arguments and have the chance to question the other party's witnesses and experts. After the arbitration, the arbitrator offers a legally binding decision, assuming binding arbitration has been selected by the parties, that determines the rights and obligations of the parties. So what are the pros and cons of arbitration? Because the arbitrator's decision is final, arbitration eliminates the risk of a formal court proceeding. But the arbitrator may make a decision that is disagreeable to one or both parties. The decision is often arbitrary, as the name indicates. Arbitration is typically more expensive than mediation. Depending on the length of the arbitration, the cost could be tens of thousands of dollars. An arbitration may last anywhere from 1 day to a week or more. Both mediation and arbitration offer benefits and risks to those experiencing conflict in a trust or estate administration. Our office typically recommends mediation as a superior option over arbitration, although individual circumstances may vary. For more information on resolving trust and estate conflicts, feel free to contact our office. If you need a referral to an experienced mediator for a trust and estate matter, check out our referral hub, which we'll link in the description box. Thanks.
We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.